or afternoon, and thank you for joining us. And welcome to our webinar panel discussion of the Clean Water Act regulatory updates and associated recommendations for project permitting. Just a couple housekeeping items here before we really get going. The webinar is being recorded and will be provided via link afterwards and made available. Please note that all of your microphones will be muted throughout the entire webinar, and the chat has been disabled. So if you have a need to communicate with us, please use the Q&A function. You can kind of see what that looks like here on the bottom of the slide being shared. All the questions submitted in your Q&A chat, we will try to get to either today during our session, and if not, we'll certainly follow up. But due to the high number of attendees, there's a chance we'll only be able to hit on a few of those. So I'm just going to briefly introduce our panel, and then we'll hear a little bit more about them as they get into some of their topics. But Noah, Greenberg, and I will be moderating the panel today. And then we have Becky, Weissman, Rick Howard, Alan, Glen, and Bonnie Rogers on our panel. Becky, Rick, and Bonnie are all senior consultants and Clean Water Act regulatory specialists at SWCA. And Alan Glen is an environmental attorney and regulatory specialist at Smith-Robertson. Here's just an overview of our agenda today. It's fairly simple. We'll be starting with a regulatory lightning round by the panelists, covering topics such as kind of the overarching Clean Water Act and lay of the land, some of the 2021 nationwide permit changes, regional considerations, and then of course, legal developments. And then we'll have a moderated panel discussion. And again, if we have time or where we have time, we'll answer some of your questions either live today and or follow up with you individually. So with that, I'll turn it over to you, Noah.
Thank you, Cara. Well, I'm really excited to introduce Bonnie Rogers, who is a Clean Water Act regulatory specialist with SWCA. Bonnie joined us in December of 2020, following practically 10 years of experience working with the Corps of Engineers and EPA in their permitting and enforcement programs. And so Bonnie's going to speak to us about some of her insight into what are the agencies doing following the changes in presidential administration earlier this year. So Bonnie, we're really looking forward to hearing what you can tell us.
Thank you, Noah. Great to have everyone here. I'm Bonnie Rogers, SWCA Waters Manager here in Southern California. I wanted to share some key actions that we've seen from the new administration. So first up, we've seen an executive order posted in January, which calls for protecting public health and the environment. This EO is basically a pause for federal agencies to reevaluate their existing legal positions and prior environmental actions over the past 4 years. So with this pause, federal agencies are to review and address recent actions that may conflict with national objectives for each of their programs. And secondly, the order revokes a 2017 executive order that repealed and replaced the Obama 2015 Clean Water Rule with most recently the Navigable Waters Protection Rule under the Clean Water Act. So with this order, we should expect to see some regulatory changes by many of the agencies. Next slide. So under this order is a fact sheet that lists all the specific actions that each of the federal agencies are to review under the EO. So these actions include the Navigable Waters Protection Rule, the Corps of Engineers 404 Nationwide Permit Program, NEPA, the Endangered Species Act, all of which had recent major revisions. So there are 104 actions to be reviewed on this list by the agencies, including Fish and Wildlife Service, the Army Corps, and EPA. So we can be certain to see another round of changes coming up for multiple programs that affect permitting and permit strategies. Next slide. So I wanted to point out specifically the NWPR, which became effective June 2020 under the Clean Water Act. This rule was a major change, most notable the specific exclusion of ephemeral waters, which are no longer jurisdictional right now. In the Southwest, over 65% of streams are supported primarily by precipitation, rain events. And so these are currently excluded ephemeral features. And the second would be adjacent wetlands, which under the new definition basically describes adjacent wetlands as those that physically touch a regulated water of the US. And that included removal of the prior significant nexus assessment. So everyone is asking what will happen to the NWPR. We can say we know the Clean Water Act has historically received pushback and litigation every time it's been modified over the decades. So we can be certain to see more criticism there. So with the NWPR, it's been in effect for over 60 days already. So that would require a new rulemaking to modify it in the Federal Register. So we might see a revision to the existing rule or a reversion back to a prior rule or maybe a brand new rule. And next slide. And then the second item I wanted to share is the executive order from January on tribal consultation. It's a memo that asks the federal agencies to strengthen their government-to-government relationships for federal actions. This order reiterates basically prior federal commitments to conduct meaningful consultation with federal tribes and calls for a new action plan on how that will be done by the agencies. So I wanted to point out here some project benefits to memos like this is that increasing engagement with tribes can actually minimize issues and concerns for your project, leading to better project success over the long-term life cycle. And so this can actually be a beneficial action that you consider in your projects. And for more details on Section 106 historic consultations, we'll be hosting an upcoming webinar, so stay tuned for that. Thank you.
You're on mute, Noah.
Next up, we've got Rick Howard, who's based out of our Houston, Texas office. Rick has decades of experience working in the water quality world, as well as on wetland permitting and delineation projects. Rick, can you tell us a little bit about the 2021 nationwide permits and some of the complexity that we have, because we have some new nationwide permits, we have some old nationwide permits with new general conditions, and then we have some nationwide permits that remain in effect as they were originally published in 2017. What can we make of all of this?
Yeah, thanks, Noah. As Bonnie mentioned, there's a great deal of chaos that's going along with developing out some of the new nationwide permits, and we expect that there's going to be additional review. But I wanted to start by talking about a little bit about the process. In January of this year, the Department of the Army published or proposed changes to the 2017 nationwide permits for reissuance of 12 different nationwide permits. Those comments went through and processed as normal and were made effective in March of this year. So as of March of this year, there were 12 new 2021 nationwide permits, most of which were just reissuances of previously administered 2017 nationwide permits. So we had essentially 10 that were changed with minor revisions that were mostly procedural, 2 that had some pretty substantial revisions, and then 4 new nationwide permits that are brand spanking new, and we all get to try to figure out where and how they want to apply. But luckily, the Corps made it fairly straightforward on what those do. You can go ahead, Noah. The main thrust of the changes to nationwide permits were fairly well described as standardizations. They removed the 300 linear foot limits for stream bed impacts for those 10 reissued permits. and they kind of settled on setting a standard acreage impact of 1/2 an acre. Additionally to those 12 reissued permits, they were harmonized to match the language in the I'm using harmonized in quotes there, to match the navigable waters protection rule, to just kind of make sense in regard to the overarching theme of the NWPR. These reflected the majority of the changes that were made for the 2021 nationwide permits, but there were 2 permits that were pretty substantially altered. Those are particularly nationwide 12 and nationwide 48. I'm going to cover 12 in a little bit more detail here because it's probably the reason why a good number of you guys are on the call. As it's written, the 2012 or the 2021 nationwide permit 12 is limited in scope to just oil and natural gas products and their product lines. So it no longer applies to other utilities other than those oil and gas projects. Other utilities have been placed into 2 of the new nationwide permits that I'm going to discuss here in a moment. The 21 nationwide permit 12 requires a PCN for any Section 10 crossing, losses of greater than 1/10 of an acre of waters of the United States as defined in the Navigable Waters Protection Rule, and or any project line that is greater than 250 miles in length. So I suspect we'll see a lot of 249.5 mile projects that are going to start rolling through. Additionally, the nationwide permit 12 no longer stipulates a PCN for mechanized land clearing. So it's no longer looking at forested wetland impacts as separate from any other wetland impacts. In addition to that, the restructured nationwide permit 12 and 48, the Corps also issued 2 new sets of nationwide permits. So you can move on to those. The first 2 I'm going to discuss very briefly. They both are for nationwide permit 55 and 56. Both deal with seaweed and finfish mariculture and set up mechanisms to permit these fairly uncontroversial projects. But the next 2, nationwide 57 and 58, deal with those utilities that were no longer covered under the revised nationwide permit 12. So nationwide permit 57 deals with electrical and telecommunication projects, and nationwide 58 deals with water, wastewater, and other non-petrochemical utility lines. The language in these 2 permits, the 57 and 58, are fairly similar to what's in nationwide permit 12. So it looks like what the Corps was doing was trying to call out oil and gas projects as separate and try to kind of parse these away from the usually more controversial nationwide permit 12s, so that it can be a little bit more streamlined for developing the discussions on how those work. So that creates some difficulty for us as permittees and as proponents of projects, and really put you in a position of deciding, well, what are we doing now? There's really kind of 3 main areas of concern for most permittees on these projects. One is if you've got a project that's authorized under a 2021 nationwide permit, those are going to be authorized just as they have been in the past, 2 years of authorization following verification of the permit. And then that nationwide permit 21, the 2021 nationwide permits are expected to remain in place until March of 2026, unless some other off-cycle process gets put into place. The next possible bin that you might find yourself in is if you've got a project that is previously authorized under 2017 nationwide permit and is still permissible under the corresponding 2021 nationwide permit. So you can think about this as like if you have an oil and gas pipeline that was permitted under nationwide permit 12 in 2018 or 2019. Since that project still fits under nationwide permit 12, since it's an oil and gas project, it would remain authorized until the 2017 permit expires in 2022. So you have this kind of weird gap year of trying to figure out whether you want to move the project forward or not in that timeline. If it's not moving forward and under construction by March of 2022, then you'd have to get it re-verified under the 2021 nationwide permit 12. The third bin that you might be in is if you've got a project that was previously authorized under the 2017 nationwide permit, but no longer fits under that corresponding 2021 nationwide permit. So say if you had an electrical transmission line that was authorized under nationwide permit 12 in 2019, That project, that verification remains valid for 12 months as long as that project is under construction. So you basically have the same timeline to get moving on that as long as it's still, as long as you were under construction at the time that the nationwide permits were altered in March of 2021. So those are kind of the more broad categories that most folks are concerned with, and I figured I'd highlight those a bit and maybe beg for questions if anybody has any more.
That's really great information, Rick. And I see a lot of questions coming in on these nationwide permits. We're going to try to work through some of those at the end of the webinar. But clearly it's a complex issue. Really appreciate you boiling it down into some simple information that we can start the process. Next up, we have Becky Weissman. And Becky is a professional wetland scientist based out of the Boston, Massachusetts area. And Becky is going to speak to us on regional considerations, which if any of you have worked in the New England states, you know that there's a lot of them. And Becky can speak to some of the regional considerations that may apply in those states, but also bring perspective from some of the transmission projects she's worked on all across the country. So Becky, what can you tell us about regional considerations during this time of flux?
Thank you, Noah. So as Noah had said, picking up from Rick's discussion on the new nationwide permits, I'm going to discuss some of the different ways that the Federal Clean Water Act can be implemented on a more regional scale. And as anyone knows who has worked across different states or different core jurisdictions, core districts, there are some important ways that implementation of the Clean Water Act can differ across the country. The most common way is through the application of regional conditions to the nationwide permits. So regional conditions are modifications to the nationwide permits that are made by division engineers, and they can only further condition or restrict the applicability of the nationwide permit. So they can't relax jurisdiction. Like the nationwide permits, they must go through a public notice and comment period. And their purpose is really to address regional differences in aquatic resources. So, for example, you might have lower thresholds for triggering a PCN or an individual permit for impacts to intermittent or perennial water courses in the more arid parts of the country, like the Southwest. And they can also have conditions that require coordination with state partners. Next slide, Noah. So in addition to the regional conditions of the nationwide permits, some core districts have, oh, previous slide, there, almost there. I think that's one slide previous. Other way. So in addition to the regional conditions of the nationwide permits, some core districts have developed regional general permits and programmatic general permits that can allow for some additional regional differences in how Section 404 of the Clean Water Act is implemented. The regional general permits are issued usually for a specific geographic area by an individual core district. So they can be specific to a state's land use. So like maintenance dredging in the Mississippi River would be an example. Or they can be broader. So like the St. Paul district has actually revoked nationwide permits for linear projects and instead relies on regional general permits for those. Programmatic general permits are typically designed to avoid duplication of existing state, local, or federal programs. And a really good example of this is from New England, where I am, where the states all have pretty robust state wetlands permitting programs. So the New England district has actually suspended the nationwide permits altogether and replaced them with state programmatic general permits, which vary by state. And so in New England, where there are more minor impacts that are already reviewed and permitted under the various states' vigorous wetland permitting programs, you may not have to file anything with the Corps apart from self-verification forms. Next slide, Noah. Finally, the other major way that the Clean Water Act can allow for regional differences is through Section 401 of the Clean Water Act, which is the water quality certification process. 401 water quality certification is required for projects that need a federal permit. And it gives the certifying authority, which is typically states and tribes, but can also be the EPA in locations where that has been delegated to the EPA. It gives them jurisdiction over activities that can discharge into waters of the United States. And this is to ensure that the proposed activity will not violate state and tribal water quality standards or other requirements of the Clean Water Act. In some states, automatic certification can be granted through the nationwide permits or with state permits. So in Massachusetts, where I am, Massachusetts grants automatic water quality certification with their state wetland permits that meet certain impact thresholds. Next slide, Noah. One more slide. Oh, there we go. So the major recent change to Section 401 has been implementation of the Clean Water Act Section 401 rule, which became effective on September 11th, 2020. So, just a few months ago. This rule is a response to the Trump administration's executive order on promoting energy infrastructure and economic growth. And this slide kind of highlights some of the major highlights of the rule. And some of those are, first of all, it establishes a strict 1-year maximum timeline for issuance. Now, the Section 401 text already states that pretty clearly that the certifying authorities must act with, quote, within a reasonable period of time which shall not exceed 1 year after receipt of a water quality certification request. But in practice, it wasn't always implemented that way in some states that use some go-arounds. But the 1-year timeline through this rule has now been, it's been backed up by court decisions, and it's now more clearly established through this rule. Another one, it also limits the scope of decisions to being specific to specific discharges, not on the activity as a whole. So in this case, the language of the Section 401 is more ambiguous, as is its legislative history, but the rule clearly now states that decisions have to be based on specific discharges. And similarly, it restricts the conditions of the 401 water quality certification to only those related to point source discharges into waters of the US. So it can no longer be related to, things like climate change, transportation, air emissions, or other project impacts. And again, this is another example of where, the language of the Section 401 is more ambiguous, and basically what it says is that states and tribes are allowed to impose, quote, any other appropriate requirement of state or tribal law. So in this rule, EPA finds that this really needs to extend to only specifically provisions that impose discharge-specific restrictions. And finally, it promotes early engagement and coordination between federal authorities, states, tribes, and applicants. And one of the important pieces of this, really promotes those pre-application meetings, having discussions, with the tribal authorities and the states and EPA, if applicable, especially in order to ensure that, there is some precedence now for EPA being able to trigger 401 water quality certification for discharges that are upstream of tribal waters. And so, making sure you're having those communications ahead of time to find out if that's something that could be triggered. So one might surmise, kind of speculate based on this, that a new or a future administration could use some of the ambiguity that's already in the original Section 401 text and as well as some Supreme Court decisions to try to pull back a little bit on this rule, to refine it, particularly as it relates to those questions of decisions or conditions based on discharge versus an activity or an overall project. And that's something we'll obviously continue to track closely. And thank you.
Great. Well, thank you, Becky. That's great information, and looking forward to hearing more about your perspectives on what project proponents can do to manage complexity as they work on projects that cross multiple jurisdictional boundaries. Next up, we have Alan Glen, who's a partner with Smith-Robertson. And I'm so glad that you're here, Alan, because so much of the content that we're talking about today is in what I consider a regulatory gray area, where there's a lot of decisions that have to be made where the law is not crystal clear, especially to us technicians. And I expect a lot of the attending operators and project proponents. So I'm hoping that you can shed a little bit of clarity on some of this uncertainty that we're wading through right now. So thanks for joining us.
Well, Noah, thank you very much. It's a pleasure to be here. Just a word about my perspective on this. It predominantly over the last decade comes out of linear projects, some of them quite controversial. I've had small roles in things like Dakota Access, some highway projects, some transmission projects, more recently a big natural gas project, which SWCA was heavily involved in. And so I do have a little bit of a linear project prejudice, but my goal in these few minutes is to briefly discuss 3 areas that I think are sort of the outstanding leading legal conundra of the Water to the US program right now. The first one I'm going to talk about here is scope of review, and that's also scope of jurisdiction. And this has been a lot in the news and certainly in the trades. As everyone knows, the Corps takes the position on these linear projects that every crossing of the water of the United States is a separate single and complete project and should be considered in that way when it comes to collateral laws. And so when you get situations such as Dakota Access, where a plaintiff is arguing the Corps should have performed a National Environmental Policy Act review on the entire 1,100-mile line, the Corps says, and the court upheld them, no, we're just going to look at our crossings. And so you have that as being sort of a fairly well-trod position now of the Corps and the courts. Two courts of the federal courts of appeals have ruled that for the purposes of the Clean Water Act and for NEPA, the jurisdiction of the Corps and the scope with which, within which they will review a project relates to the crossings in their immediate vicinities. Other questions, however, come up, both under the National Environmental Policy Act, but also under the National Historic Preservation Act and the Endangered Species Act. And over the last decade, there has been sort of an overwhelming lack of clarity on what the solution is, and we've all been struggling through it. I'll drop down and start with the Endangered Species Act because we do now have some clarity there. And what happened was beginning in 2017, the U.S. Fish and Wildlife Service and the Corps of Engineers had an exchange of letters that they envisioned as the approach they both agreed to handle these so-called small handled projects. And that would mean those big linear projects where the Corps has some number of crossings it's evaluating and is required to consult with the Fish and Wildlife Service under the Endangered Species Act. Well, what's the scope of that consultation? Corps had always taken the position that it was just the immediate vicinity of the crossing. Fish and Wildlife Service has pretty much always taken the position that it was a much larger area. They resolved that it would be a larger area. The exchange of letters, though, didn't quite give it the legal underpinnings that I think it deserved, and so it's still a matter subject to litigation. And in the natural gas pipeline project, I think I mentioned that I worked with SWCA on, that issue was litigated. It didn't actually reach conclusion, but it was litigated. So what's resolved with the Endangered Species Act is that with the 2019 new Section 7 regs having to do with consultations under the Endangered Species Act. The service envisions that when the Corps has one of these projects, it will submit a biological assessment that evaluates not only those areas under its jurisdiction, but also those areas that are really under the control of the applicant and are upland and removed from the areas of Corps' jurisdiction. And then the Fish and Wildlife Service will conclude that consultation with a biological opinion that allocates, as between the Corps and the applicant, which terms and conditions are applicable. And that also authorizes, therefore, the applicant in the uplands away from the Corps' jurisdiction to cause the anticipated take of endangered species. Very briefly, the same sort of issue has run through the National Historic Preservation Act under the Section 106 provisions. In the Dakota Access case, the National Advisory Council took the position that the undertaking, which is the word from the act, was in fact the entire, for the Corps, was the entire pipeline, and the Corps disagreed with that. Ultimately, the court sided with the Corps, saying that the undertaking was not that broad one. So we can go to the next slide, I think. Thank you. The other thing that's been hot lately and kind of feeds into what I like to have people think about in terms of what can they do to protect themselves in this very changeable set of circumstances. We've now had two different nationwide or of nationwide implication cases on the consultation obligations of the Corps when it adopts the nationwide permit. The first one was filed in a federal court in Montana as an attack against the Keystone pipeline. But one of the grounds for the attack was that with respect to the 2017 nationwides in total, the Corps had failed to properly consult under the Endangered Species Act with the Fish and Wildlife Service. So you had a project attack that ended up being decided on an issue of national importance, and it was decided against the Corps and is now up on appeal to the Ninth Circuit Court of Appeals. There is not a broad scale injunction, however, in place. Initially, the district court did enjoin the Corps' further use of nationwide permit 12, but that's been rolled all the way back to now. It's just a project specific injunction. And then now most recently in this month, after the new round of nationwide permits came out, we've got what I'm calling Montana number 2. Similar set of plaintiffs have filed a similar lawsuit back in Montana District Court, challenging the lack of complete consultation that they allege the Corps failed to undertake in connection with the 2021 new and changed nationwide permits. That leads me to this question, and we'll talk about it more in the Q&A, but you know, you're getting to, and this happened to us in the gas pipeline that I worked on with SWCA, you're getting to where events of national significance get brought against your project. So in that gas pipeline, we were under litigation when that first Montana court case came out, and we got a new claim from the Sierra Club basically saying, apply that ruling in this case, which would have stopped the project. And again, ultimately it was resolved, but not on those merits. What I believe that people can do, and I'll expand upon this in Q&A, but you really need to think about, what are you going to show the court if the court determines that through no fault of the projects, there's a defect that is sort of national significance? And my view of that is you need to show the court that notwithstanding whatever position the agencies were taking at the time, there's enough in the record and there's enough analysis to say, we collectively actually considered where it would go if it came out this way. And so that's in the record. Two things there. You might get a court say, well, it's really kind of no harm, no foul. I'm not going to enjoin this project. Or if the judge does enjoin the project, then you at least have the work done and you can turn to it quickly to get it redone and out. So next slide, I think. So I won't spend much time on this. There has been litigation on what do waters of the United States mean for so long now. It's been one of the most litigated environmental issues at the Supreme Court. And as we've already described, the Trump administration rule is currently in effect across the country with a strong expectation that there will be some form of new rulemaking that will cut back against it and bring it to some more inclusive standard in terms of what areas are considered waters of the United States. Ephemeral streams are a very likely target there. One thing, as I was preparing for this, that I thought was interesting, though, is if you really look at the history of the jurisprudence on waters of the United States, no agency, no Corps of Engineers, no EPA is writing any longer on sort of a blank slate on how they can interpret the law. The Supreme Court, through 3 sequential decisions, has really cabined and constrained what they can do. So it's not really the case that it's no holds barred, it could be anything. There are limitations. Just a quick example. So some of you may remember what was called the Swank case. And what that held was that the prairie potholes that don't have a connection to traditional navigable waters would not be considered jurisdictional merely because migratory birds flew into them. So they're not bringing prairie potholes back unless they have some other real convincing way to argue it. The Supreme Court has constrained that. So that's my quick review of 3 areas of litigation that are of interest to me. And I do feel for those of you who are consultants on these matters and also for project proponents, this is a really complex time to be doing these things. And of course, it comes at the same time that delivering all this infrastructure is a critical need. So good luck and best of luck to all of it. And Noah, thank you again for allowing me to be here.
Well, Alan, that's great. Thank you so much for that information, and really a lot to think on there. And I want to hear more from you in a few minutes, though, on some of the things we can do to manage this risk. So now we're going to shift into some panel discussion, and we have some questions that we've developed that we want to let some of our panelists walk through and give you some insight into the ways that we're thinking about these. So the first question that I have for Alan and Rick is, what are some practical approaches for minimizing the risk to projects with constant regulatory uncertainty? There's rules are changing, the law is changing, but we need our projects to move forward, and we want to do it in a way that's lawful with the smallest amount of risk possible to project schedule and future risk. Alan, can you give us some tips on what we can do to manage this risk?
Yeah, Noah. So it goes back to something I mentioned, that you need to think about what can you put forward to a court as an alternative reason to let you go away, even though some of this external regulatory uncertainty has put your project in jeopardy. And so you want to work very openly with the agencies and say, if that happened, what would this look like? And I give you an example, and that's probably the best way I can answer it. If you have a long linear project that is going through, for the Endangered Species Act, this small handle approach, you're going to find in litigation that you're going to get an argument that you should have pursued, instead of Section 7 consultation for the uplands, an individual incidental take permit under Section 10. What will take some of the sting out of a plaintiff bringing that claim is if you can fairly demonstrate in your record that, well, you know what, we looked real hard at the question of perhaps a Section 10 permit. And what we did is we adopted measures that would be everything you would reasonably expect to get in that permit. I call that, Judge, it's no harm, no foul. Maybe we didn't do exactly the right procedure, but we did the right things substantively. So that'd be my answer to that question, is try to get in the record evidence that those scenarios were thought through.
Yeah, good advice, Alan. Thank you. Rick, how would you respond to this question?
Well, I would say from a really practical standpoint, one of the things that I've been doing for many of my clients is providing guidance on both the existing regulations and the regulations as previously proposed, because we we consider it, or I consider it to be a reasonably good probability that the navigable waters protection rule might be rolled back. And so I want to make sure that my clients are aware that what may be considered permissible right now may not be if by the time they get ready for construction. We're kind of in this weird twilight where we know there's going to be, as Alan was stating, we know there's going to be some legal action and some alteration to the navigable waters protection rule, most likely. We just don't know when that's going to happen and when that's going to lead to kind of this this surprise stoppage of what most people have as nationwide permits that are just kind of clipping along through their process. So providing that helps to give some guidance to the client as to how quickly they want to move a project through and what their pacing might be for that project.
Bear with me while I get my slides back up.
There you go. I was going to say, while you're doing that, now I could pose
Great.
a
Well,
question.
Alan and Rick, thank you for that information. Second question, Alan, I'm hoping you can help us address this first. What is the realistic risk to existing agency determinations on projects? And in particular, I'm interested in approved jurisdictional determinations, regarding what is and what is not a waters of the U.S. Can you speak to that at all?
Yeah, more practically probably than legally. It's been my experience with the Corps of Engineers that they do try to treat an applicant or a permittee fairly when they can in this changing circumstance. And so I think, I have a circumstance right now where essentially it was a covered ephemeral and is no longer. And, the Corps is really trying to work with the applicant to figure out how to bridge that period of time. The risk, on the other hand, really, I think, is not so much from the agency as it is these third-party plaintiffs. And unfortunately, all it takes is some, well, not even paper, some electrons, and I think a $250 filing fee for somebody to file a lawsuit, and there you are. But my advice across the board is work with the agency, work transparently with the agency, and tell them what concerns you. Tell them, the scenarios that you're trying to account for.
Thanks, Alan. Now, for a slightly different perspective, Bonnie, I'm hoping you can, help us see this through the lens of a Corps of Engineers project manager, and what might they do when confronting some of these situations where perhaps a feature was given a non-jurisdictional determination under this existing regulation, but the regulations change and perhaps become more expansive, such that the feature would be jurisdictional under a future rule. What would be the way to approach those situations?
Yeah, those are all good questions. Like Alan mentioned, if you received an approved JD from the Corps, the Corps is going to honor that in almost all cases. But there's a scenario where sometimes you pursue an approved JD and there are both jurisdictional and non-jurisdictional features on the same project site. And so in that case, as the regulations change into the future and you go back to begin implementing your project, that might sort of muddy the clarity of which features on site are jurisdictional and which aren't. And so, in that case, I would recommend, if you're pursuing an AJD where you have both types of features, that you also pursue your permits simultaneously so that you can get coverage for those anticipated impacts, and that you have a very clear picture of what's jurisdictional and what required a permit at that point in time.
Yeah, thanks, Bonnie. That's great and sounds like good advice. Moving on to the next question. What are some tips for managing complexity associated with projects subject to regulation by multiple state and federal agencies? And this is really something that's going to become, at least regionally, an increasing burden on projects. And, for example, in Colorado right now, we are, in the midst of the state is promulgating new dredge and fill permit programs to address gap features. And I understand Arizona is undertaking a similar process. Becky, you've worked with these issues, across the country, but especially in New England. What can you tell us about some tips for success on these types of projects?
Yeah, no, as you had mentioned previously when you were introducing me, I am in the Northeast, and it certainly has its share of complexities due to overlapping regulations. And so just as kind of an example, a linear project that maybe goes from New York into Massachusetts, you could be dealing with not only at least 2 different core jurisdictions, but also 2 different state wetland acts. And in Massachusetts, we also have, many of our municipalities have municipal local wetland bylaws. So all of these different overlapping regulations could mean end up defining wetlands in different ways. They could require different forms of mitigation, and they could have different construction BMPs. So it really can become complicated. So one thing that I find is helpful is, as much as you can, trying to get a joint pre-application meeting with the various stakeholders. And sometimes you can try to negotiate and find some common grounds that could reduce that complexity. But sometimes you can't. Sometimes you're tied by by the regulations and by the rules of the various jurisdictional authorities. So then it becomes how to manage that complexity and keep track of it. And one of the most useful tools that I found has been having geodatabase referenced permitting matrices to track regulatory jurisdiction of various wetlands, applicable permit requirements, schedule considerations, best management practices during construction or time of year restrictions, setbacks from wetlands. And so that really helps a lot, those kinds of tracking matrices. But also really good solid mapping can also provide a visual that shows the various jurisdictional differences all in one nice map or figure.
That's great. Good advice, Becky. Thank you. So moving on, next question, and I really want to hear Bonnie speak to this. Bonnie, what are the risks with proceeding with construction in aquatic resources that appear to be non-waters of the U.S. under the Navigable Waters Protection Rule without obtaining that Corps of Engineers approved jurisdictional determination? And this is a question that I've gotten a lot, especially with ephemeral features or isolated wetlands. Folks want to know, can we go in there and do construction? Is it really necessary to coordinate with the Corps? What can you say to those potential risks?
Yeah, this is a really good one. With the new rule, the exclusion of ephemeral waters, has opened up this question of whether or not you need to approve JD before you conduct work in an ephemeral stream. But the outcome here is that there's a high risk of pursuing impacts within a non-jurisdictional stream without getting that determination and verification from the Corps of Engineers. Like I mentioned earlier, in the arid West, we have a lot of ephemeral and intermittent streams, and differentiating between those 2 types of streams can be really tough. There's a new tool that the Corps is piloting right now, the stream duration assessment method, in order to better determine the differences between those 2 types of streams. But you really want to rely on the experts in order to make that call before you go out and conduct projects in a water that you think is ephemeral that might not be.
Yeah, that's great. So, proceed with caution if that's the approach, because there's potential that rules can change or that there could be some disagreement over, some of the information about the aquatic resource and whether or not it really is non-waters of the US. That's good guidance. And then for our final panelist question, Ellen, this is going to come back to you, and regarding some of your presentation, what explains this apparent difference in resolving scope between National Environmental Policy Act, National Historic Preservation Act, and the Endangered Species Act? Can you shed some light on this question, please?
I doubt I can shed much light on it, Noah, but I'll try to speak to it. This is one where I continue to be stumped. Just the other day, I had an attorney from the National Advisory Council on Historic Properties tell me that, however the ESA or NEPA were done are not relevant to determining the scope under 106 because they're different laws. I have looked at how one defines action, undertaking, et cetera, in each of these laws, and I'm not seeing it, to be candid. I think we still have a situation where there are some inherent inconsistencies in the way both the agencies and the courts are looking at these issues of the scope of appropriate review. The interesting component is sort of the most favorable view on the NEPA issue, favorable to industry on the NEPA issue, is pretty well solidified in the courts of appeals. And I don't see that as going up to the Supreme Court. So what that may mean is that there'll be pressure on some of these other statutes on those programs to start looking more like the resolution on NEPA, which was to limit the scope of review. But by the same token, the Fish and Wildlife Service and the Corps have clearly tried to expand it for ESA, and that can be convenient. So it's a mess. I don't have a solution to it, but I do think that there are, people can say all the time, oh, they're different statutes. They say they use different language. It's an inherent inconsistency.
Great. Yeah. Thank you, Alan.
Noah, it looks like we have a number of questions that have been posed via the Q&A and a few minutes left here to get to a few of these. Do you want to pose some of these to our panelists?
Yeah, thanks, Cara. So we have a couple of questions regarding nationwide permits, and I'm hoping, Rick, that you can help us look at two of these. The first question is regarding the general conditions, and the question is whether or not the general conditions may differ depending on which nationwide permit was used. What are your thoughts on that?
There are certainly a few alterations in the general permits, and I think that Bonnie spoke to that as well. But there are some differences in those general permit conditions, and so it's possible that as you're looking at your specific nationwide permit requirements, that it may be different, may differ whether it was based on the 2017 or the 2021 standards. So it's probably really important for you to review the permit issuance date and make sure you know when it was verified under the nationwide permit before you just start in on the project.
Yeah, that's great. One additional nuance, and maybe it doesn't apply to some parts of the country, but one of the general conditions, that you spoke to, Rick, is that the elimination of that 300-foot limit that applies to nationwide permits 29 and 39 and a couple of the others. In balancing that, the Corps actually is now requiring mitigation for losses of stream bed, which exceed 0.03 of an acre for those nationwide permits where the 300-foot limit was taken away. And so that's something that's catching some folks by surprise. So it's really important to make sure that either you or your consultant is reading a lot of the fine print because, as they often say, the devil's in the details. Mm-hmm. Another question that we have on nationwide permits, Rick, is regarding water pipelines. And if a water pipeline was being considered, and maybe even the pre-construction notification was submitted to the Corps before that March date of implementation of these new nationwide permits, are those going to be now considered under nationwide permit 58, or do you think that they would continue to be processed under nationwide permit 12? What are your thoughts on that question?
So I would expect that in this particular scenario, and Bonnie can probably speak to this a little bit too, that in that particular scenario, your core project manager will be reaching out to you to discuss moving it from a nationwide permit 12 application to a nationwide 58 application, because they want to make sure that they're issuing it under the correct permitting vehicle for you. Ultimately, it's up to the applicant to make sure that it's being submitted properly. So it's probably a good idea to get back in touch or have your consultant get back in touch with the Corps. But in this particular one, they should be offering that olive branch to you as part of getting it properly applied, because the nationwide permit 12 under which it was previously applied or under which you sought verification is no longer valid, or at least not valid for an unissued permit applications. So they should be encouraging you to move that one over to a 58 as you move through the finalization on the permit process.
Yeah, I would agree with that, Rick. If you're in the middle of the permit process, the project manager at the Corps is going to be helping you figure out how you can get your project into that new nationwide permit.
Great. Thanks, Bonnie. Thanks, Rick. Cara, it looks like we're getting up to the top of the hour, and as so much of the subject matter is, it's really hard to answer these questions adequately in 1 or 2 minutes. So I'm going to suggest that we follow up with the attendee questions offline. If you did submit a question and we didn't address it specifically, now we'll make sure to email you answers. And if anyone else has questions that they didn't pose, please reach out to us. We really enjoy talking about this, and all the panelists are excited to engage with you on your questions.
Great, thanks, Noah, and thank you to the panelists, and thank you to all the attendees. We really appreciate your interest in these, and we have recorded this, as I mentioned at the top, and this will be posted and available on swca.com, and as a participant or registrant, you'll receive an email with that link. So look out for that. And then, as Noah mentioned, any of the questions we didn't get to today, we will be following up. Bonnie alluded to this earlier. We had scheduled another webinar in the series talking about the National Environmental Policy Act and the National Historic Preservation Act, and we've had to postpone that. We're working on a new date, so more to come on that webinar, and that will be the final one in our 3-part series here. So again, thank you to the panelists, and thank you to all our attendees. We're delighted.